All right, now we'll talk about cross-examination. After direct examination, now the other side gets to attempt to impeach your witness. And by impeach, I mean they want to make them seem somewhat less trustworthy, somewhat less believable, have a poorer memory, have a reason for bias, and basically that's how we get into cross-examination. Really a couple different kinds of cross-examination. One approach is what we would call a direct cross-examination, and that would be going directly at a person. You can't see 15 feet, can you? You wear glasses and you weren't wearing them. You didn't hear it. You'd been drinking. You didn't remember. Anything that would attack the immediate recollection or position of the person through that very witness, through themselves usually. Constructive cross-examination is more sophisticated, and the best example I have of that is in the O.J. Simpson trial. A detective, Mark Furman, who was one of the main witnesses, testified, and he was asked whether he had ever used the N-word. And he said no, and they said never, ever, ever. And he said nope, and they said not when you were in high school, not when you were a teenager, not when, never, ever, never. And he said no. And that was all they asked him, after a series of other questions, of course. But on that question, that was all they ever asked him. They did not make any headway about that issue on using the direct approach to cross-examination. Using the constructive approach, though, they next called a witness who was an author and who had, I think, 8 hours of tapes of Mark Furman discussing a possible book with the author. And trust me, the N-word was used repeatedly. So that's constructive cross-examination. Cross-examination will generally use what we call leading questions. That is, it has the answer in the question, and you'll usually know a question is a leading question if it requires just a yes or no answer. One of the biggest problems with cross-examination is when people sort of veer off and start telling their own story rather than the one you asked them. And that's when people do it differently. They'll either ask the court or they'll interrupt the witness and say, I'm sorry, I asked you a yes or no question. Just answer that question. Sometimes courts will get involved. If you need to, you can ask for that. But that's generally the way that leading questions are used in cross-examination, attempting to pin a person down, get them to admit to yes or no what they know and what they don't know. Once you're done cross-examination, you get to do some redirect. So the plaintiff has asked a series of questions. The witness has now been cross-examined, and now you can use redirect to visit areas that were not otherwise covered in your examination. And it's limited, and you can only try and rehabilitate your witness through them. The defense can recross based on the things you asked on redirect. But again, some courts will keep you on a very short leash. You won't get to ask a lot of questions. Once that's all been completed, then at some point the plaintiff will run out of witnesses and the court will ask if the plaintiff rests, and you'll indicate you do. Often at that point, the defense will make a motion to dismiss, indicating you haven't proven your case. It's done as a matter of course. Sometimes they're successful if you haven't proven your case. Oftentimes the court will listen to it and will indicate that it's time for the defense to put on their case. And then what you have is a mirror image. They'll call their direct examination of witnesses. Those folks will be asked questions in the same manner, the 5 W's and an H. And now the plaintiff will be cross-examining the defense witnesses, and they'll use the same types as they did. There'll be a redirect and a recross. And at some point, what will happen is we will end the testimony. All of the witnesses will have spoken, and at that point, the court will start to put together the final pieces of the case. Next to the opening statement, probably the next most important part, most people would say maybe the more important part, will be the closing statement. And the closing statement will be that really kind of exciting part where people will try and really get the jury's attention on all the inconsistencies of the other side's case and all the good parts of your case. Ladies and gentlemen, did you hear what the defendant said when he was asked what have you? And you really try and pinpoint the major points that you made and the major misses that they had. The defense will go first. The plaintiff will follow. In federal court, you'll do a rebuttal if there is some areas that were mentioned in one closing that the other side didn't get. They will come in and add it. Then at that point, the court will give the jury instructions. We've done jury instructions. And if there's a need for it, there will be jury interrogatories that will accompany the juror when they deliberate. The jurors will go and deliberate at that point in time. And depending on how it goes, they'll hopefully reach a verdict. You need 5 of 6 people to vote in favor of one or the other. And at that point, they reach a verdict. When the verdict is announced, then oftentimes there'll be a request for an entry of judgment after the verdict has been settled. You'll try and reach that. You'll submit a judgment so that it will conform to what the jury's verdict was. In the meantime, the other side, if they don't like what happened, will file a motion for a new trial. Very difficult to win on a motion for a new trial because you're going to go back before the judge that just heard all the evidence in the case, and you're going to have to say, Judge, I think you made mistakes during the case, and I want you to order a new trial. Usually that's not very successful, and the very next step that people have to take is an appeal. And that is all I'll say about trials for the moment. Thank you, everybody.